The formation and constitution of business organizations. Introduction. Welcome to Module 4 of ACCA F4 Corporate and Business Law, focusing on the formation and constitution of business organizations. In this video, we will explore different types of business organizations, the process of company formation, legal personality and the concept of limited liability, distinctions between company constitutions, share capital fundamentals and the responsibilities of promoters. Types of business organizations. Business can be structured in three main ways. Sole trader, owned and operated by one individual. Simplest form of business structure. Partnership, two or more persons carrying on business together. Shared responsibilities and profits. Company, corporation, separate legal entity from its owners. Two main types, private limited, LTD, and public limited, PLC. Each structure has different legal implications and requirements. Sole traders. Sole traders represent the simplest form of business organization. Characteristics. Owned and operated by one individual. Simple setup process with full operational control. Unlimited liability. Personal assets are at risk for business debts. Mathematical example. Business generates profit of $25,000. If business incurs losses of $30,000, owner's personal liability equals $30,000 to $25,000 equals $5,000 from personal assets. This unlimited liability is the major disadvantage of sole trader status. Partnerships. Partnerships involve two or more persons carrying on business together. Key features. Governed by Partnership Act 1890 in the UK. Partners share profits, losses, and business responsibilities. Joint and several liability for partnership debts. Mathematical example. Partnership debt equals $60,000. Three partners, A, B, and C. Creditors can recover the full $60,000 from any single partner. Each partner is potentially liable for the entire debt. Companies. Companies represent the most sophisticated form of business organization. Key characteristics. Legal personality separate from owners, shareholders. Limited liability. Shareholders only liable up to amount unpaid on shares. Can own property, enter contracts, sue, and be sued in own name. Mathematical example. Shareholder purchases 1,000 shares at $2 each. Total investment equals 1,000 times $2 equals $2,000. If company fails, shareholders' maximum loss equals $2,000 only. Personal assets remain protected. Private versus public companies. Understanding the key differences. Share transfer. Private company, LTD restricted transfer of shares. Public company, PLC shares freely transferable. Minimum capital. Private company, no minimum capital requirement. Public company, often $50,000 minimum, £50,000 in UK. Shareholders. Private company, minimum 1 shareholder. Public company, minimum 2 shareholders. Stock exchange listing. Private company, cannot list on stock exchange. Public company, can list shares for public trading. Incorporation process. Forming a company involves several mandatory steps. Step 1, choose appropriate company name. Step 2, prepare Memorandum and Articles of Association. Step 3, file registration documents with Registrar of Companies. Step 4, pay required registration fee. Step 5, receive Certificate of Incorporation. Once incorporated, the company becomes a separate legal entity. Promoters. Promoters are individuals responsible for forming the company. Key responsibilities: taking steps necessary to form the company, arranging initial capital and investors. Fiduciary duties include acting in good faith toward the future company, avoiding conflicts of interest, making full disclosure of any personal interests. Promoters may be liable for pre-incorporation contracts unless the company later ratifies them. Legal personality of companies. Companies possess legal personality distinct from their members. This means company is a legal person under the law, exists independently of its owners and directors, has perpetual succession, continues despite changes in ownership or management, can enter legal relationships in its own name. This concept is fundamental to corporate law and business operations. Limited liability. Limited liability protects shareholders from personal responsibility for company debts. Key principle: shareholders not personally liable beyond unpaid amount on shares. Mathematical example: company has 10 shareholders. Each owns 500 shares at $1 per share. Individual liability per person equals 500 times $1 equals $500. Maximum loss per shareholder equals $500 regardless of company's total debts. This encourages investment and business formation. Memorandum of Association. The memorandum records the initial formation of the company. Contains essential information. Company name and intended purpose. Location of registered office. Initial share capital structure. Details of initial subscribers, founding members. This document provides evidence of the intention to form a company. Articles of Association. The articles contain the internal rules governing the company. Key areas covered: voting rights of different types of shareholders, procedures for appointing and removing directors, dividend distribution policies, rules for conducting meetings and passing resolutions. These rules are binding on the company and its members. Company constitution. The company constitution comprises two main documents: Memorandum of Association, records initial formation details. Articles of Association, contains internal governance rules. Together, these form a binding contract between the company and its members. Members among themselves. This contractual relationship governs internal company affairs. Alteration of constitution. Companies can modify their internal rules when necessary. Requirements for changing articles. Special resolution typically required, usually 75% majority vote. Changes must be lawful and legal. Must be made in good faith. Must be in the best interests of the company as a whole. This flexibility allows companies to adapt as they grow and circumstances change. Share capital basics. Understanding different types of share capital. Authorized capital. Maximum amount company can raise through share issues. Issued capital. Value of shares actually allotted to shareholders. Paid up capital. Amount shareholders have actually paid. Mathematical example. Authorized, 100,000 shares at $1 equals $100,000 maximum. Issued, 80,000 shares equals $80,000 issued to shareholders. Paid up, 80,000 times 75 cents equals $60,000 actually received by company. Company records and disclosure. Companies must maintain comprehensive records. Mandatory registers. Register of members, shareholders. Register of directors and secretaries. Accurate accounting records. Record of significant transactions. Public disclosure requirements. Annual returns filed with Companies House. Financial statements available for public inspection. Major changes in company structure must be reported. Advantages of incorporation. Incorporation provides significant benefits. Separate legal identity from owners. Limited liability protection for members. Business continuity despite changes in ownership. Enhanced access to capital through share issues. Increased credibility and professional image. Perpetual succession ensuring ongoing existence. These advantages make incorporation attractive for serious business ventures. Conclusion. We have explored the fundamental aspects of business organization formation. Business structures range from simple sole traders to complex corporations. Companies offer legal personality and limited liability protection. Formation requires compliance with specific legal procedures. Promoters have important fiduciary duties during formation. Company constitutions provide the framework for internal governance. Share capital structures determine ownership and financial arrangements. Understanding these concepts is essential for anyone involved in business formation or corporate governance. Thank you for joining us for this comprehensive examination of business organization formation and constitution.